You have a right to remain silent, otherwise whatever you say might be used against you in the law court. When last did you hear this expression? Well, how often do you hear it? Well, we usually say this when law enforcement agents, conduct an arrest on suspects, and basically this expression flies always. But let's put some reason or make sense out of what it means when this right is being expressed by the law enforcement agent to the suspect that you have a right to remain silent. Well, we can only do this on the program Law and You. Welcome on board with me. And we're going to be looking at right to remain silent, when and how to use it. And discussing this with me, I have a legal practitioner, and he is Emmanuel Obapolo. Thanks for being here.
Good afternoon, Philip. Good afternoon, Nigerians.
All right, let's look at it, because we usually say this, and now we should be talking about what it means exactly. So can you give us legally what this term means?
Yeah, right to be silent is sacrosanct, and it is provided for in the Nigerian laws, particularly in section 35, subsection 2 of the 1999 Constitution as amended. It does provide that a suspect can choose to be silent until he consults or upon consultation with a legal practitioner of his choice or any other person that he chooses. Paraphrase now. And also, this provision is in conjunction with section 36, subsection 11 of the extant Constitution. Section 36 of the subsection 11 of the Constitution, paraphrase, provides that no person on trial can be compelled to say anything. He can choose to remain silent.
Yeah.
Then section 11, section 6 of the Administration of Criminal Justice Act is also in consonance with that provision. And section 180, paragraph G of the Evidence Act provides that a person can also choose to be silent. Particularly when it's on trial, you cannot bring trending issues for the person to answer questions. He can choose to be quiet. So what it means is that the right to be silent is sacrosanct. And evidence has shown that most times the security agencies, particularly the Nigerian police, only seem to exercise that right to be silent upon the arrest of an individual or group of individuals.
Or suspect.
So suspect, as the case may be. When they come to arrest the person, at the point of that arrest, you can exercise that right. But after that, they go, when you get to their office, they will now let you to know that that right does not exist. But even in consonance with the extant Police Act 2020, that act recognizes the right to be silent.
Okay. So well, let's look at the importance of this right.
Yeah, the importance of the right is that most times when a suspect or any person is being arrested, you discover that the right to be silent is that so that the person will make his or her statement in consonant with the events or the suspicion of the crime alleged to have been committed. Most times, when a petition is against a person, the best thing for that person to be done upon arrest is to be silent and consult with a legal practitioner of his choice, so that the legal practitioner will now be there to direct the person on what and what to be said, on what and what to do when the person is to give his or her statement. But we have come to see that the presence of the legal practitioner is only but a guide. He can be seen present when the statement of the person is being taken, but it cannot say anything. It cannot be heard. It can only be seen. But then, before the statement is taken, the suspect said to be arrested or the person or any person or persons, as
Yeah.
the case may be, said to be under arrest, must have first discussed with his legal practitioner to tell the legal practitioner what he knows, facts, with respect to the offense alleged.
Yeah.
And that is why it is sacrosanct to also tell the person being arrested why the person is being arrested. And that's what Section 6 of the Administration of Criminal Justice Act 2015 provides for. You must tell the person. But that is the provisions of the law. But in practice, we have come to see that most times persons are arrested for not knowing why they are arrested, perhaps until they get to the office of the security agency that arrested them.
They are not told.
You must, as a matter of fact, particularly when that arrest is by warrant of
Yeah.
arrest, let the person know the reason,
For his
the
arrest.
purpose for which the person is arrested. But whether or not it is followed by the security agencies is another matter for another day.
Okay, well, thank you for giving us this very, very beautiful direction, and let's build on it. At what point can we say this right of the citizen cannot be enjoyed?
The right,
Is it in the courtroom? Because there must be a time when it's expected that the suspect speaks. What if the suspect chooses not to speak? Like during questioning by the police, we've had a case like this where the recent one being the Sahara Reporter publisher, Sore, that refused to speak. I think that's quite a full-blown picture of the exercise of this right. So, to what extent can we say that right can be refused?
like I did say, the right is sacrosanct. At the point of arrest, even the police will make you to understand that you shouldn't say anything. You should remain silent, because whatever you say can be used against you in the court of law. That is what they tell the suspect at the point of arrest.
Yes.
So that is at the point of arrest. The police recognizes that right.
At the point of arrest.
And that right can be exercised at any time, even on trial. Section 36, subsection 11 of the extant constitution does provide that on trial, a person cannot be compelled to answer any question.
On trial?
Yes.
When you say on trial, are you talking about the courtroom?
Courtroom now. It cannot be compelled to answer any question.
But what
The
we
person
usually
has-
hear silence is consent.
Silence.
So if you don't speak, it then means that what you are being accused of, you are guilty of it. Or what does it mean?
It is not in all cases you would say silence is consent. It is when there is an affidavit evidence. Maybe the person is to answer questions based on what he or she has deposed to in his or affidavit.
Oh, yeah.
When you
On oath.
depose to on oath now, and the question is put to you and you remain silent, it shows that you have consented. But not when maybe the person does not understand the question put to him or her, and you are now forcing or compelling, as the law provides for, compelling that person to answer that question. That person has right to be silent. So at the point of arrest, like I did say, on trial, the person can choose to remain silent and exercise that right to be silent. Because, like I said, that right is sacrosanct. That right is provided for by the law. It's a protection for the suspect or the accused person or the defendants, as the case may be. It's a protection. So, the law provides for Section 17 of the Administration of Criminal Justice Act, if my memory judges me correctly, provide that any person that is being interrogated by the police, the person has right to have the presence of his legal practitioner or a family member. So, where you are interrogating a suspect, so to speak, at the police station, you must have the presence of his lawyer or the presence of a family member to witness that the person was not forced, was not under any form of duress to give that statement. And the law provides for this, because before now, we have seen that so many persons have come to court to say, oh, I gave this statement under duress.
Oh, yeah.
Because I was forced to. I was beaten. I was asked to sign upon after the police wrote the statement by themselves, for themselves, with themselves. I was only asked to append my signature. So that has become another hurdle upon trial. So to do away, to ensure that such excuse or such defense is no longer maintained by a defendant or an accused person on trial, the law ensures that this witness, these persons as provided for by the law, should be present when the person is making his or her statement. So you cannot see that right to be silent is sacrosanct. And must not be abused. And the courts specifically frowns at it when it is abused or violated.
You made mention of the fact that everyone enjoys his right. Does that include crime suspects?
Yes. Particularly, just as the suspect or the defendant enjoys that right, he also has right to fair hearing. Because as at the time that the person is being interrogated or cross-examined on trial, where the person deliberately keeps silent not to answer that question, the law provides for that. It's his or her right. But then he can also choose to express himself where he understands that the question being put to him does not connect to him. But when the question put to him with in respect of the crime so alleged, and he chooses to be quiet, it is now the duty of the court, upon evaluation of the facts before the court, to know and come up with a valid judgment, to know whether or not that person has committed that crime. So whether you are silent or whether you give information with respect to the alleged offense committed, it is the right of that individual.
Well, let's quickly take a break. In case you're just coming across this program, it's Law and You, and we're looking at the right to remain silent and what does it mean and when and how can it be applied. And I've been speaking with Emmanuel Obakwalo. My name is Philip Omo-Gyukman. We'll take a short break. Do stay. Good to have you join us still. Well, let's look at this aspect. If one has the right to remain silent, I remember you spoke about, the need to, if the person, the suspect has the right to legal counsel or having, a lawyer. Do you also mean that the right to remain silent can also mean to speak through your lawyer?
Yes, in some cases, it means that.
That means the lawyer can speak
particularly
on issues that the court, for instance, or on issues that is demanded that you give information to.
When an accused or a defendant is on trial, he speaks through his lawyer. That is not to say that his lawyer will answer questions for him.
Because we can see in the law courts where we have cross-examination.
Yes, that is not to say his lawyer will answer questions for him. His lawyer is only there to guide him. And where there is need for clarification, it is duty bound on him to express himself. But where he chooses to observe and obey the right to be silent, and at the close of the day, all fingers point to him that the alleged offense was committed by him, he cannot now say that he was being victimized. because he was the one who exercised his right to be silent. So he cannot now say that he was not given fair hearing to express himself, because the law ensures that as much as the person, as provided for in section 35 subsection 2 of the Eastern Constitution of the Federal Republic of Nigeria, that he has right to be silent, the law also provides for in section 36 of the same constitution that he has right to fair hearing.
Of course.
So
certainly.
you can be heard to say your own side of the story, but where you deliberately refuse to say your own side of the story, and the alleged offense, all fingers point to that accused person or defendant that he committed it, he cannot now come later to say, oh, I was not given opportunity to be heard, because he was the one who exercised his right to fair hearing.
Okay, good one. Well, let's see at a point where one is not having a lawyer, for instance, and then he's been arrested and being questioned. At what point can you call it not sensible for the suspect not to speak?
Well, there are instances where the suspect or accused person may not have the ability or capacity to afford a legal practitioner.
Exactly.
But the law itself now says, at the point of his being interrogated at the police station or in the custody or presence of any security agency, that he can consult a lawyer or a family member of his.
Okay, if he does not have the wherewithal to get a
a
lawyer
at the custody of the security agency. But in the court oftentimes make provision for a legal practitioner for him.
for free?
Yes, free, pro bono. I have been asked twice or three times to take over a matter where the person, the accused or the defendant, does not have the wherewithal to get a legal practitioner. The court provides for him or her. And also we have the Legal Aid Council. The Legal Aid Council provide, the Nigerian Legal Aid Council provide a legal practitioner for him to defend him. We also have lawyers, individuals who can also assist in that regard. Also, the Nigerian Bar Association, if they are aware of it, they can also get a legal practitioner or more to represent him pro bono, free of charge.
Okay.
So the excuse of saying that I cannot afford a legal practitioner is not tenable.
Okay.
Just now.
Okay.
Particularly with the provisions of these laws that states that you have right to be silent and right to be heard.
Well, it's getting interesting and more mind-boggling, most especially if we introduce the aspect of making statements, where the law enforcement agent will tell you, you have to write a statement, make a statement on what transpired so that they can get information about, the issue that they are getting at. Does the right to remain silent include the right not to make statement?
Yes, it includes it. But that right, to every right, there's an exception. Because all rights do not have the toga to be perpetual, so to speak. What I mean is that as much as you have right to be silent upon interrogation, that right is only exercisable when you don't have a legal practitioner representing you,
okay,
or members of your family.
Okay.
That's when that right is exercisable.
All right.
But if you choose to say that I want to be silent perpetually, when you are charged to court, the court will provide you a legal practitioner.
Okay.
And then issues will emanate on when, how, and where the person was arrested, and for what offense?
Thank you very much.
Alex.
Thank you very much, Emmanuel Obakpolo, for taking our time to be part of this. We're going to throw more light into some shady areas, most especially as regards, writing statements. And at what point can we say a suspect making a statement could be shot in the foot or could be implicating himself? But that will be a spillover into the next episode. Well, this is much you can take. Big thanks for joining us. We'll see you in the next one. Goodbye.